We're now 2 weeks into the occupation of Ottawa by the truckers' Freedom Convoy. And finally, some residents of the downtown Ottawa neighborhood took the convoy and its organizers to court. And I'm going to talk to Professor David Wright, who is the faculty of law at the University of Calgary and a co-author of an ABLAWG post called Rigs in a Parlour, the Freedom Convoy and the Law of Private Nuisance. So welcome to the interview, David.
Thanks, Markham. Good to be with you.
Well, I think I can speak for a lot of Canadians when I say, frustration at inaction on the part of various governments in resolving this issue. And so private citizens had to take action on their own. And lawyer Paul Champ has brought already he's got an injunction in an Ontario court. And your blog post partly deals with that. Maybe just kind of lay out the argument for us.
Sure, Markham. So the context is as you described. We won't go into more detail, although we can as we get going here. But this lawsuit hinges on what's known as the the tort of private nuisance. And what this blog post does is simply walks through the legal analysis that any court would use and that the court did use in this instance to understand if this is a substantial and unreasonable interference with the rights of the residents in downtown Ottawa. So we walk through it, apply it to the facts, and conclude that the legal arguments available to the plaintiffs are indeed quite strong and persuasive. And you see that, we saw that earlier this week with the court granting the injunction early on.
So the question is that they already got the injunction, and then there's going to be the issue of damages. So let's walk through the process. And so the first question that you asked in the post is the interference substantial? What's your take on that?
Yeah, so it's a two-part test. It comes from the case of Antrim Trucking, which is a Supreme Court of Canada case from 2013. Two-part test. First question is the interference substantial, as you say? Very low bar threshold test. And basically, this argument is quite easily satisfied in this case because any interference that goes on, sort of trivial annoyances or everyday interference that a plaintiff might experience, satisfies this threshold question. And then you move on to the meat of the analysis, the more in-depth analysis to see if the interference is, quote, unreasonable.
Well, let's talk about that. That's the second part of the test. And you set out a number of, or you addressed a number of issues in the blog post, character of the neighborhood and so on. Maybe you could run through those for us.
Yeah, so this is a balancing test. So the court is looking at the alleged interference and using several points of law to understand whether or not it does constitute unreasonable interference. So the court will look at the character of the harm. So historically, physical harm quite clearly satisfies this test, so damage to person or property. In this context, we're in the realm of what's sometimes known as amenity nuisance, which is a little bit cryptic, but it means that anything like sounds, odors, and so on that affect the plaintiffs can be considered to be of the character that constitutes nuisance. And you see that with the blasting of the air horns in Ottawa exceeding 100 decibels day and night and so on, or before the injunction was granted, you saw that. Similarly, character of the neighborhood. So it may be fine to be out in the middle of nowhere blasting an air horn where no one's around, sort of out in a wide rural area, but downtown Ottawa is not that type of environment, and so it's far less appropriate in a neighborhood like that. And the factors go on, but just to summarize really succinctly, duration matters. This has been going on and on. The sensitivity of the plaintiffs matters. Plaintiffs ought not be unduly sensitive, and indeed they're not in this context. Breach or compliance with statutory rules. In this context, we have a number of breaches of bylaws, regulations, health and safety standards, and also the intensity of the interference. This is quite an intense interference, or was while it was happening, and the courts will take note of that, and did indeed in granting the injunction.
There's also the nature of the defendant's conduct, and I think this is transfixed the nation and anyone looking on from outside. While or a portion of the protesters may have been there for legitimate reasons, there were a lot of folks that were up to mischief in that neighborhood.
Yeah, so nature of the defendant's conduct is another factor to be considered. We cover it very briefly in the blog. And essentially, if there is an intention on the part of the would-be tortfeasor or the interferers on their part to annoy, frustrate, harass, or cause discomfort to the plaintiffs in this case, then that factor also tilts toward this being unreasonable conduct. And it's hard to see this situation, at least for some of the folks engaged in this activity, not having that kind of conduct or that kind of motivation behind the conduct. Indeed, as you've probably seen on Twitter, folks have stated that fairly openly. And there's also the other factor of utility of conduct. And so everyone is quite aware that we have freedom of expression in this country. It's a very good thing. And the court will look to the utility or usefulness of the conduct in determining whether or not it's unreasonable. But in this context, and you saw in the verbal interaction with Justice McLean in the injunction hearing, that there are other ways to make this point known. And the blasting of the air horns and truck horns simply isn't a necessary part of that kind of freedom of expression. And therefore, it's of lower utility in the calculation to see if this is unreasonable conduct.
Now, you conclude in the post that the plaintiffs have very strong arguments for a private nuisance suit for damages. Can you explain that, please?
Yeah, so in any given civil suit, you're looking to see what kind of remedies might be available. So in this context, they initially sought an injunction and were successful in that. Now it's only 10 days and the parties will be back in court on February 16th to see if that's still needed or to see if there's an extension may be required and so on. But the longer term lawsuit here is a full-blown trial potentially for damages. And so to the extent that the plaintiffs, and this is likely to be certified as a class action lawsuit, so a number of residents in Ottawa together with one named plaintiff, that's just the standard procedure. It will be up to them to establish that they have experienced enough harm and damage, likely to some degree permanent damage, or at least financial damage. So some may have had to go and get hotel rooms, buy some kind of sound dampening devices, even earplugs and so on. It'll be up for them to quantify that and convince the court that they are entitled to these damages. Much more evidence will be tendered at a trial like that, and there'll be much more robust analysis. The analysis that the court did on Monday takes place when time is of the essence and when a temporary remedy like an injunction is being sought. And so there's still areas, and you would have heard this in the live proceedings for the injunction. There's sort of cursory treatment of the evidence to see if there is a serious issue to be tried and see if harm is actually happening. That's been satisfied. Now things will go a little bit deeper. So
we'll have a trial. How do they identify the defendants? I'm very curious about that. I mean, the residents from the neighborhood have come forward and identified themselves to the lawyer, this Paul Champ. But how does Paul Champ identify who he's suing?
Yeah, good question. And it's going to be challenging. And just to be clear, Maya and Martin's analysis in the blog post really focused on the substance of the private law nuisance analysis. And we didn't really delve into these on the ground details, but they are important and they have come up actually in some of the Twitter responses. Well, we know that there's been some documentation of individuals and vehicles. And so it really will be up to the plaintiffs to gather as much of that up and to identify and figure out how to serve those folks with additional legal notices and to make sure that they are full-blown, that they are fully integrated into the lawsuit. And so it will be interesting to see how that's done. But in today's day and age with smartphones and so on, it's quite likely they'll be able to track down, again, individuals' vehicles and perhaps, again, their employers. And there's issues of vicarious liability there and trying to figure out who the most appropriate and viable defendants will be for these plaintiffs to pursue.
Well, David, thank you very much for your insights. Really appreciate this.
Pleasure, Markham. Thanks.